Welcome to Key Talking Points.
The podcast that makes learning effortless.
No fluff, no jargon, just clear, engaging explanations.
We break down complex topics so you don't have to.
Let's get straight to the point.
Visit keytalkingpoints.com for more.
All right, to start us off, let's tackle the basics. What exactly is bankruptcy? In the simplest terms, bankruptcy is a legal process that gives individuals or businesses overwhelmed by debt a way to reset. That's the big picture idea. Essentially a second chance to financially recover.
Exactly. It's like pushing the big red do-over button when things just spiral out of control, isn't it?
That's one way to think about it. Interestingly, the concept of bankruptcy isn't just a random invention. It's actually rooted in the US Constitution. Article 1, Section 8, Clause 4 grants Congress the power to create bankruptcy laws, so bankruptcy, in some form, has always been baked into the system here.
Wait, really? I had no idea it went that far back. So it's more than just a system for creditors and debtors. There's a constitutional foundation for it.
Absolutely. But here's where it gets interesting. While bankruptcy laws are created by Congress at the federal level, state laws also play a significant role, especially when it comes to property rights and exemptions. For example, states can establish rules about what kind of property a debtor gets to keep, like a family home or certain personal items, even during bankruptcy proceedings.
So that's why you might hear people saying things like, oh, filing bankruptcy in California is completely different from filing in, say, Texas. The state laws create those differences, right?
Exactly. And speaking of differences, the Bankruptcy Reform Act of 1978 was a turning point. It overhauled the earlier system and gave us the modern framework we still use today. It was designed to balance the rights of debtors and creditors more equitably. So it's fair to say that it reshaped US bankruptcy law into what we recognise now.
Okay, I've got to know. How transformative are we talking? What kinds of changes did this act bring?
For one, it introduced the Bankruptcy Code, which created structured chapters to handle different types of bankruptcies. It also made the process more predictable, ensuring it wasn't just about wiping the slate clean, but also about protecting creditors' rights in a fair, consistent way.
Right, because before that, I imagine it might have been all over the place. Different systems for different states, no cohesive structure, and so on?
That's exactly it. Now, one of the biggest misunderstandings about bankruptcy is the long-term stigma attached to it. People think it's the financial equivalent of wearing a scarlet letter forever.
Oh yeah, I've heard that myth. How if you file for bankruptcy, it'll haunt you for life.
But that's not quite accurate. Yes, a bankruptcy filing stays on an individual's credit report for years, up to 10 for Chapter 7. But it doesn't mean you can't recover. Plenty of people and businesses bounce back financially after bankruptcy.
I mean, isn't it kind of the whole point, to get a fresh start and move forward?
Exactly. It's there to act as a safety net, not a life sentence. Though it is worth understanding the implications, like potential limitations on credit access and that public record of bankruptcy itself. But honestly, it's more about educating yourself on what happens post-bankruptcy.
Right. And we're here to bust those myths, aren't we?
Absolutely. Bankruptcy might sound like a scary word, but it's really just a tool, a framework to address unmanageable debt while still ensuring fairness between debtors and creditors. All right, we've laid out the broader framework of modern bankruptcy law, so now let's focus on the structure of the Bankruptcy Code itself. It's divided into various chapters, each designed for specific scenarios. The most commonly known ones are Chapter 7, Chapter 11, Chapter 13, and Chapter 9. Why don't we begin with Chapter 7?
Oh, Chapter 7. That's the one where everything gets liquidated, right?
Exactly. Under Chapter 7, a trustee is appointed to gather all non-exempt assets of the debtor, sell them, and distribute the proceeds among creditors. But here's an interesting fact. For most individuals filing Chapter 7, they don't have any non-exempt assets to liquidate. These are often referred to as no-asset cases because people keep basic, essential possessions. It's the most common form of bankruptcy, particularly for individuals.
Right. And I guess that's why people often see it as a last resort. The ultimate surrender of assets to start over.
Absolutely. Then there's Chapter 11, which is all about reorganisation. It's typically used by businesses, allowing them to keep operating while restructuring their debts.
Kind of like saying, give us time, we'll figure this out and keep the doors open.
Spot on. A perfect example is Lehman Brothers. Back in 2008, they filed for Chapter 11 in what became the largest bankruptcy filing in US history, over $600 billion in assets. It sent shockwaves through global markets. Chapter 11 filings like that allow a business to reorganize, negotiate terms with creditors, and hopefully emerge as a functioning entity.
Wow, so it's not just for mom and pop shops, it's for giant corporations too.
Exactly. But then we have Chapter 13, which is all about individual debt adjustment. Instead of wiping the slate clean like in Chapter 7, Chapter 13 allows people to keep their property while they pay back creditors through a court-approved plan, usually over 3 to 5 years. It's like restructuring, but on a personal level.
Oh, so it's kind of like saying, hey, I can pay this off, just not now and not all at once.
Exactly. Now, Chapter 9 is a bit different. It's specifically for municipalities, cities, towns, even school districts. A notable example is Detroit, which filed for bankruptcy in 2013. It was monumental, not just because it was the largest municipal bankruptcy in US history, but because it highlighted the incredible financial pressures cities can face and the challenge of balancing their obligations to creditors and their citizens.
And what happens to, let's say, public services during something like that? Do they just stop? Or does the city find some way to keep functioning?
Great question. Municipal bankruptcies are about reorganisation, not liquidation. So the focus is to keep essential services running while restructuring debts. For Detroit, it meant renegotiating with creditors, selling off assets like artwork, and cutting back on some pensions and services. It's often messy, but the aim is to stabilise and emerge stronger.
Okay, but switching gears a bit, what about student loans? I mean, you hear all these stories about people drowning in debt they can't discharge no matter what chapter they file under. Why is that?
Student loans, one of the most controversial areas of bankruptcy law. Generally, they're considered non-dischargeable, which means you can't wipe them away, except under very rare circumstances of undue hardship. Critics argue this is unfair and traps people in overwhelming debt, while others believe making them dischargeable would destabilise student lending and educational funding systems.
It's such a tricky balance, isn't it? On one hand, you want accountability, but on the other, you've got people who just can't catch a break.
Exactly. And add to that, the automatic stay. This legal shield pauses collection efforts like phone calls from creditors once the bankruptcy filing begins. It's intended to give debtors breathing room, but it doesn't apply to everything, like those dreaded student loans. Now that we've looked at some of the challenges individuals face in bankruptcy, let's explore how modern changes in the law have shaped these dynamics. One major development was the Bankruptcy Abuse Prevention and Consumer Protection Act, or BAPCPA of 2005. While it aimed to prevent abuse of the system, it also made Chapter 7 bankruptcy harder to access for many individuals.
Oh, so instead of just being able to file for bankruptcy when needed, people had to meet stricter requirements?
Exactly. The law introduced a means test to determine eligibility. Essentially, it checks if your income is below the median for your state. Those above it might have to file under Chapter 13 instead, which involves a repayment plan. Advocates argued this would prevent people from abusing bankruptcy as an easy out. But critics point out it disproportionately impacted lower-income individuals who were already struggling.
Right, so instead of helping people get back on their feet, it made the process more complicated for those who really needed it. That's frustrating.
It is. And speaking of barriers, that's where the automatic stay can be a lifesaver. As soon as someone files for bankruptcy, the automatic stay kicks in. It's like hitting a pause button on creditor actions. No more collection calls, no lawsuits. It provides immediate relief.
That sounds like a bit of a breather for anyone caught in the whirlwind of debt collectors. Finally, some peace, if even temporarily.
Exactly. But it's not a cure-all. For instance, the automatic stay doesn't apply to all debts, student loans being one of the notable exceptions we mentioned earlier. Still, for many, it's a critical buffer during an overwhelming time.
So, it's like a timeout to figure out the next moves, right?
That's a great way to put it. And let's not forget about the larger implications of bankruptcies. cases like Lehman Brothers in 2008. Their Chapter 11 filing was a colossal shock, marking the largest bankruptcy in US history at the time. It had over $600 billion in assets, and its collapse rippled through global markets, sparking discussions about policy, regulation, and economic resilience.
Wow, that's mind-blowing. It really shows how bankruptcy isn't just about individuals or businesses. It can shake entire economies.
Absolutely, and it forces us to rethink how we approach financial stability and risk management, both at a personal and systemic level. These events shape how society views bankruptcy, not just as a last resort, but as a mechanism for recovery and recalibration.
It's kind of incredible, really, how something as seemingly personal as financial distress connects to these huge, sweeping systems. It changes how you think about it, doesn't it?
It does, and I think that's the takeaway. Bankruptcy laws were designed to balance individual needs with broader societal and economic stability. Whether it's a family trying to keep their home or a corporation restructuring billions in debt, the system serves to reset and rebuild.
And on that note, I think we've managed to cover quite the spectrum, haven't we? From the basics to the big picture impact, it's been fascinating.
It truly has, and that's all for today. Remember, understanding these systems not only empowers us to navigate financial challenges, but also to appreciate the larger forces at play. Thanks for tuning in.
Yes, thank you all for listening. Until next time, take care and stay informed.